Thank you, Markus, for that kind introduction. I think it has become a pattern to, first of all, disclose that I have a legal background as well. So apologies for that if you're a technician and you find me to be too lawyerish. But on the other side, I think dealing with the topic here, it is of no harm, let's say. So talking about liability, GDPR, sanctions, and the industry standards that we think we see slowly, but see developing. When I accepted to talk on this occasion here today, I had certainly hoped to be able to bring many more insights and many more decisions from data protection authorities. But there certainly is, and Ulrich Kelber this morning alluded to that, talked a bit about the pipeline of cases that data protection authorities are handling. And that I think we will see some more decisions come out of this in the next foreseeable future. I always regretted throughout the years since I started to focus on GDPR, I regretted the heavy focus that usually was put on sanctions and fines. No, it has become really this kind of mantra. You have to comply with GDPR because there are fines of up to 4%, of up to 20 million euros. And former head of data protection authority in the Netherlands said, data protection authorities should not just bark but bite. And I think the sanctions regime in GDPR has become somewhat the enabler for that. Now, on the other side, so far, we have seen a very divergent pattern of decisions, of fines. There are the smaller ones. Baden-Württemberg here in Germany in the Knuddel.de decision, 20,000 euros. Then on the other side, 50 million euros against Google, obviously a company of a much bigger size, much bigger turnover, much bigger annual profit. Yet the authority, the CNIL in France, I think was a bit short in defining how they reached that number, how they concluded that 50 million would be appropriate. And on the other side, we then have a couple of other very small fines, 4,800 euros and so on. And on the other side, the US, the FTC, the recent FTC decision with about $5 billion US dollars. I mean, that's a different number, right? That we see in the US. And as I said, I had hoped to be able to share some of the more recent insights with you and decisions by the Irish Data Protection Authority in particular, because you will know that they sit on a pile of cases involving all the household names of big tech: Apple, Facebook, WhatsApp, Instagram, Snapchat, and some more. And unfortunately, we have not seen any guidance there yet. So let's discuss a little bit what we've seen and what the trends are. Berlin is said, the Berlin authority is said to sit basically on a decision that is to be published in the near future, quoted to be a multi-million euro fine, but it seems no one knows. If you do, then come to me after the talk. No one really seems to know what that case is about, what the company is, and so we're all sitting there with suspense and waiting for that outcome. More recently, the Information Commissioner's Office in the UK announced in 2 cases its intention to fine 2 companies, Marriott and British Airways. So they have not fined yet, but they published their intent to fine them. In the case of Marriott, about 100 million British pounds. In the case of British Airways, close to 200 million pounds. And there are a couple of interesting lessons to be learned from these decisions. One is, in both Marriott and BA, we saw that the companies immediately went to the stock markets and filed ad hoc notices to the markets to inform them about that impact, which in turn means we need to consider whether people who are involved in handling a breach in a company or in a law firm have insider role, have insider qualities, and therefore should refrain from trading securities during that phase. In addition, I think we have seen in both cases that there was a heavy focus on security, and I think that is a bit of a pattern we see so far, that many of the decisions are really built around poor security. and try to sanction these poor security practices. And then finally, it also shows that you can acquire risk through V&A or through M&A activities. Marriott acquired Starwood, and that is how Marriott got fined. It was for poor security practices in Starwood. So I think the lesson learned here is that it is much more important to focus also on what you buy and do a proper due diligence, in particular in the data privacy space. And I don't think this has become a regular pattern so far. So how do we prepare for situations like that? How do we react to what we see happening in the market? That's what I'm going to discuss today. In a very broad scope, there are a couple of potential objects for these sanctions. We always talk about the fines against organizations. That's obviously number one. The controllers, the processors could be fined. We also need to take into account that, for example, under German law, management could be fined individually for not taking action, for not setting up a control system, a management system to prevent such non-compliance. Other responsible individuals, like people working in the company, making the wrong call, making the wrong decisions, could be fined as well. So the average employee is certainly also a potential addressee for sanction decisions. We have not seen that very often yet, but I do think that it will not remain like that in the data privacy field. One could talk about the liability of the DPO. I would have done that if I had more time than the 30 minutes today, but so I'll leave this out for now. Data subjects could also be subject of a fine. For example, if they use wrong identity to access data, filing a subject access request purporting that they are someone else, that could potentially lead also to financial and even criminal sanctions. And data privacy authorities can be subject for fines if they remain inactive and if they don't address breaches, if they don't address complaints properly. So a lot of reasons and types of sanctions as well, from criminal over administrative fines, monetary sanctions, the corrective powers, just to mention for completeness. And then on top of that comes the contractor liability that I'll go to touch on at the very end. And there is a kind of complicated overlay, because while the GDPR discusses the what and the how much in Article 83, it doesn't exactly determine who will get fined, how that is going to work, what legal actions, what legal remedies are available to organizations and to individuals alike, because that is left very much to the member states, and therefore there is certainly a limit to the harmonization that we will see in this field. So focusing first of all on non-contractor liability and risks, there's obviously Article 82 and 83 that provide for these fines. I keep this short because that is probably very familiar to everyone now. I think it's worth calling out that there is a risk of joint liability of controllers and processors that is usually not limited, because you will often not have a direct contract with an individual that effectively limits that liability. So in a nutshell, an affected individual has the choice to sue the controller or the processor or both, and then they will need to sort it out later. So that is the joint liability that I think puts both controllers and processors at risk, and I'm going to address later on a little bit one of the consequences that this brings. We do have comprehensive rights for data subjects. We do see that they are sometimes used to prepare for litigation, in particular in the employment field. I think not so much in Germany yet, but in other countries like the UK, it has become a standard pattern, a standard approach to file a subject access request if you want to prepare for employment litigation. So the disgruntled employee that has maybe been laid off, that has had to leave the company, then brings action against the company, that will very often lead to privacy complaints and subsequent information. And we've also seen first couple of cases where there was compensation, not just for material, but also immaterial damages. For example, a very recent decision in Austria where the Austrian Postal Service was fined because they profiled inhabitants of Austria for their political affiliation, and that led to a fine assessed against the Austrian authority. So we've seen this broad range of fines, and what I think we would like to see as a company is to have more guidance, to have a better understanding of what we have to calculate with, what the risk really looks like. And so far, I think there is not much work has gone into that field. We have now seen two interesting developments, one in the Netherlands and more recently also in Germany. They have come up, well, the Netherlands have formally come up with sentencing guidelines, to use that US term. The Germans have come up with a draft that is very unofficial, but is somewhat circulating on the internet as well. So the Dutch DPA said, we're going to define in more detail how we will use the criteria, the catalog of Article 83, which is quite detailed, quite lengthy, but still doesn't provide any real guidance on how high a fine could look like. And they said we will classify the potential violations of GDPR into 4 categories. So category 1 to 4, and then we will associate a certain bandwidth, a certain amount, with each of the categories. And they have listed in the official Gazette, in the official publication journal of the Netherlands, how they're going to deal with that. So as an example, they would say we have this bandwidth here between €0 and €200, which is the lowest category for simple violations. The starting point, as always, would be the midpoint of that range, so 100,000. And we would say if joint controllers fail to enter into joint controllership arrangement, if organizations fail to notify us of the DPO that they have implemented, that they have nominated, that is a relatively low category, relatively low type of non-compliance, and we will start with that relatively low number. And on the other side, at the end of the scale, you see those bigger fines in category 4, still 450,000 to 1 million. You could say, well, that is reasonably low if you compare it to the up to 20 million, up to 4% framework. And then they would say this applies to mishandling, mistreating of special categories of data or automated processing and profiling. So I think that is a very interesting approach. You could obviously debate the numbers and what happens if you're a big organization, then they will probably go above these numbers quite a bit. But I think it helps to understand better the line of thoughts of the authority. As I said, the German authorities have come up with something similar, which is unofficial, which I think is more a leaked paper that has not been formally adopted or agreed and seems to be still under discussion. It seems to be a very German approach. It was said to be 30 pages long, very detailed, probably like a tax declaration. You have to take all types of criteria into account, then a per day value is calculated, then there are points, then there is aggravating and other factors that need to be taken into account. And I've heard that the first companies are already working on implementing some kind of GDPR fine calculator website. So curious to see what that means. But I do think this is an area that needs to have more consistency across Europe. And I think that is something where regulators should also be more transparent around what they really see, because it helps companies, it helps organizations to prioritize their area of focus. A completely different area is competition-based claims and notices, and I'll keep this very short, but there is a lengthy debate in Germany going on whether data privacy violations, non-compliance with GDPR could serve to provide a cease and desist notice in competition law. And the short answer, lawyerish answer, is it depends, because there is no clarity yet. We have seen various decisions by various courts in Germany. I've listed some here on the slide in very small print. I do hope you can still read those if you're interested. Otherwise, the slides are available for download. But I think there is no general agreement yet on a couple of important things. So the competition law aspect remains something to watch, remains something where we have no full clarity yet, and it will probably take a while to see these trends emerge. So on one side, there's a group of scholars that say GDPR intended to come up with a complete system of sanctions, and there is no room, there is no space outside of GDPR to deal with sanctions in a different way. So competition law should not interfere with it, it should stay outside. We have to use the instruments provided by GDPR for data privacy violation and not use competition. I don't think that is very likely to stay. I do think that the appetite is certainly there to deal with that and use competition law as a vector to regulate behavior of organizations in the marketplace. Others have argued that you need to look into the rules and whether they wanted to really regulate behavior in the marketplace or not. And I think there's also an interesting case, just to mention for completeness here. The Federal Cartel Office in Germany recently told Facebook not to pull together data from various sources, in particular data from WhatsApp and Instagram, and on the other side, third-party websites, and pull all that together to profile people, and argued primarily with competition, broad competition arguments for that, but also argued that data privacy, data protection rules would indicate a potential misuse of market power and therefore should be considered. Now, the OLG Düsseldorf, the court in Düsseldorf, didn't uphold this decision, but as an injunctive relief said, we will look into that in more detail. So I think it is something that the Düsseldorf court will continue to look into. But that's why I think competition is certainly an area to watch, in particular because we also see that regulators on the competition side and data privacy side work much more closely together and share insights and share data. So that's certainly an area to watch. On the other side, I think I wanted to also briefly mention an interesting decision by the Bundesgerichtshof, the Federal Court of Justice, who basically said in a 2017 judgment, and that tells you that it's obviously not about GDPR and it wasn't about data privacy. But the court said when you assess a fine, when you determine the level, the amount of the fine, it is necessary to take into account what the company and what the top management of the company have done to prevent such breaches from the beginning, or even only in reaction to a breach that has occurred, have updated the system. And that's what I think that there is a clear conclusion that it is worth investing into data privacy management systems and into other compliance management systems as well, because it is a factor that needs to be taken into account when making decisions about sanctions. How has the company prepared to prevent such breaches, but even more, how has it reacted to an actual breach? And I think that is something that is a message that is worth sharing also with top management in our organizations, because it shows that there is a potential return on investment also at this end of the discussion. Now let me also focus a bit on contractor liability and limitations. So the first part obviously was about the kind of outside environment. What do data protection authorities do? How do they think? How do they prepare? How do they react to issues that they see? And what are the lessons that we can learn? I think equally interesting is to discuss the patterns, the developments that we see when it comes to contractor liability. That's obviously not possible between companies and in the B2C market to a large extent, because either you don't have a contractual relationship with people who use your website, or alternatively, you have at least limitations in limiting your liability for intent and gross negligence. But this focuses very much on the contractual landscape between controllers and processes that controllers select and use. So German law has, I think, a very simple starting point by saying the parties are liable for all attributable causes that they could reasonably foresee. And the legal starting point is, the legal basic ground rule is this limit liability is unlimited. So if you don't try to limit your liability by contractual means in any way, then you will be held accountable for all sorts of violations with no upper limit. And that is obviously a consequence or an economic risk that many organizations will not be able to share. And the parties have obviously diverging interests. A controller would always want to have unlimited liability, arguing that they bear all the risk of wrongdoing on the side of the processor as well, whereas the service provider or processor will say, I need to limit my liability contractually to make this whole setup economically feasible for me. I think it is also necessary to, as I briefly mentioned, consider additional legal requirements. So, for example, in standard terms and conditions, the allgemeine Geschäftsbedingungen in German, you cannot limit your liability, or you cannot exclude your liability for gross negligence, and obviously also not for intent. So that is, I think, a starting point in which we now see certain developments, certain patterns, how companies react to that, and some of the developments. So a practical view of what I think we see in the marketplace. I'm curious to hear whether you share that view, whether you have made completely different experiences in the past year and a half or so, or 2 years. I think, first of all, it is always necessary to consider applicable law. So, for example, in a B2B environment, you could work with a choice of law and then exclude thereby the application of the rules on allgemeine Geschäftsbedingungen, on standard terms and conditions. I think it is also not really the case, maybe not yet, that GDPR really leads to more frequent liability scenarios. I think there is we've always had privacy risks, so I don't think we have seen so far an increase in the cases in liability discussions between controllers and processors. Parties tend to agree on limitation in our view, but they don't do that just as part of an overall cap, but what we see in the marketplace is we see specific rules for data privacy, for data protection liability. So it is usually carved out from the standard liability regime and put into a special regime dealing specifically with data protection incidents. And that usually comes with a super cap, which means there is a higher level, a higher limit of liability, or in turn the risk for the processor is much bigger. And we see two main types here: either a special regime for everything related to data privacy, or sometimes at least an increased level or an increased cap. We think that we see more increased caps than standalone data privacy liability regimes, but that is something to be discussed. We also think that there are regional trends. We see much more limitation of liability in the US, in the UK, and in Northern and Central Europe, while in Southern Europe, the appetite, let's say, or the willingness of parties to agree on caps seems to be pretty minimal at this point. I don't really have an explanation for why that might be the case, but it is something that our data shows. So in addition to that, I just wanted to mention that we frequently see a somewhat time-consuming debate around where confidentiality and data protection meet, because obviously confidentiality arrangements often will be very broadly worded, and that broad language brings the risk that there is an overlap, and you could qualify an incident, an issue, often as being a confidentiality one, in which case one regime would apply, or a data protection one, in which case another regime would apply. And that is something that one should probably focus on when negotiating a contract. But I think the most important thing is to not focus on limitations alone. I think if you focus your energy on negotiating liability limitations in the contract, you're at risk of failure, because what is much more important is to clearly delineate the areas of responsibility of both parties, or of all parties if there are more parties involved. So as an example, on the information security side, I think it is of crucial importance, given that many of the decisions, the sanctions by authorities also were related to security, to clearly delineate who is responsible for what, who has responsibility to take security measures in what area, because that is helpful to just avoid any dispute from the beginning, and hopefully, should something go wrong, have also a clear way to describe or to document whose responsibility it was. On the other side, and finally, I would also recommend to think about reciprocity of these clauses, because so far it's always been a processor who tries to limit its liability. I think it becomes also more relevant for controllers to think about whether in their perspective a limitation of liability would make equal sense, because given the joint liability under Article 82 and the possibility that an individual can choose which party to sue first, I think it is much more important to make sure that controllers also think about this type of risk and appropriately limit their liability. With that, I think we have a couple of minutes left for questions or comments. And as I said, I'd be happy to hear from you about the experiences you've made so far. And apart from that, I think we're all sitting here being very curious to see what other sanctions and the decisions there might be in the pipeline with regulators. And I do think that in particular the Irish regulator have heard and have well noticed the pressure they saw on the European Data Protection Board, and are probably quite busy working on some of the sanctions decisions that I would personally expect to see before the end of the calendar year. Thank you.